Ms. Robinson.
Good morning. May it please the Court, Stella Robinson representing Eric Anderson. The defendant is asking this Court to reverse his conviction for first-degree murder on the ground that statements he made to police and to two inmates should not have been admitted. I'd like to address the inmate statements first. There were actually three inmates. Two inmate statements are an issue here. Evan Holtman, with whom he was incarcerated in Norfolk, testified to misogynistic, extremely hostile misogynistic statements made by the defendant, including statements that you have to take a woman out or else she'll take over your life, she'll get you in trouble. And he also described a pinup that was mutilated by basically cutting out the breast, cutting out the genital area, and cutting the throat. The Commonwealth describes this pinup as a reenactment of the crime. In fact, it was Holtman saw it approximately 10 years after the crime in question. And the fact that the genitals and the breasts are targeted is not really that significant. There are only so many erogenous zones, and if somebody is expressing, sort of sexualized hostility towards women, that's basically how it's going to be expressed. So mutilating a pinup in this way is not, can't reasonably be considered a reenactment of the crime. It's really another bad act, and an extremely prejudicial one, because it's propensity evidence in essence. It's saying he is the sort of person to commit the crime charged.
Are you saying it would not be permissible for the jury to infer or to conclude that this was a reenactment?
Right.
I mean, we're talking about, is this relevant? And if it's relevant, is it more, probative than prejudicial? I mean, couldn't the jury conclude under these circumstances that this was a reenactment that the defendant kept with him?
Not reasonably. There's no evidence that this was created any time before 1987.
Well, wait a minute. First of all, it comes in as a statement of a party opponent.
Yes.
If it's relevant to the issue at trial.
Well, it comes in as a statement of the defendant, yes.
Yeah, and so it comes in for that reason. And if it's relevant to the crime, and it's not just the pinup. It's statements that he made.
Right. There are other statements.
There are other statements that he made that may not have matched up completely with the way the crime was committed. But the pinup and the statements really taken together, aren't they? Doesn't that really just go to the weight of the evidence and not its admissibility?
No, I think it's brought in supposedly as an admission of the crime charge.
Yeah.
But it really can't reasonably be considered admission of the crime charge.
Why can't it be?
Because the fact that it would have to have the kind of unique similarities.
Well, you're grafting. You're trying to graft the prior bad act language onto the admissibility of a statement of a defendant, of a party opponent, and I don't see how you can legitimately do that. It comes in.
I'm saying that essentially that's how it's ending up coming in. It's because it's
that's
not
how
in
you're
fact
saying.
an admission of the right. If it's not an admission of the crime, then what it's really functioning as is
Why
a prior
isn't
bad
it?
act.
Why couldn't the jury take it as an admission of the crime?
Or an
Because
admission
it
of a desire to commit a crime of that nature.
Well, that's just propensity evidence, and that's just evidence that he is the kind of person who might commit such a crime. Although I think
By
there's
his own admission, he thinks doing this sort of thing to women is a good idea.
right. That's propensity evidence.
And it links up with the distinct features of the crime he is alleged to have committed.
Well, what I'm saying is these distinct features are not really so important, that if if you have that propensity, if you are that type of person.
Well, you see, but you seem to be confusing propensity evidence with admissions of the defendant. Propensity evidence is typically some act that a defendant committed that somebody else is testifying to. This is a statement by the defendant himself.
Correct, and it's brought in as an admission.
Yes.
And I'm saying that it could not properly be brought in as an admission because it doesn't have enough similarity with the crime charged to really be identified.
But that only goes to the weight of it. It doesn't go to its admissibility.
It's a sort of a boasting quality.
I don't think any statement by a defendant is admissible merely because he's a party opponent.
I see what you're saying. If the defendant had admitted in the course of a statement to a whole series of completely unrelated crimes, you could say, well, that's a statement of the defendant, but on the other hand, it's also, actually, it's unrelated and it's prior bad acts, and so there would have to be a special basis on which to...
Right, and I'm saying that it's neither proper to bring this in as an admission, and that because if it's not an admission, it's functioning as prior bad act evidence, and it's improper prior bad act evidence, because it does not have the kind of similarity that would identify it as a signature kind of a crime, because these similarities are not truly important where anybody who fits that kind of profile is going to be targeting the same body parts. The Commonwealth has argued that this is something unique, that it's highly improbable that two different people would mutilate a body in the same way, although one, of course, is a body and one is not.
It doesn't have to be highly improbable. The question is whether it's probative, and that may depend on some ruling that it's similar enough to be probative, or it's suggestive enough of the kind of intent or plan or modus operandi or whatever.
Propensity evidence may be very probative, but it's still improper because we only convict somebody for committing the actual act charge, not being somebody who...
I understand that, but what I'm saying is you say it's unrelated. And what I'm saying is couldn't a judge on deciding whether to admit this evidence determine that it was sufficiently related, sufficiently an admission with respect to this specific crime because some of the very specific pieces of it that seem so similar?
If you look at it from the point of...
That it would be a jury question to decide.
If you look at it from the point of view that you assume that he committed the crime and then ask whether this describes the crime, there are similarities. But I think you can't properly look at it from that perspective. The real question is if you look at this description, would you identify it? Or there were really two descriptions of crimes in this case, Evan Holtman's and Carol Saint-Germain's. If you ask yourself, does this describe the murder of Ruth Masters, the answer is no, because Saint-Germain, he says that he cut a woman up on the South Shore and she almost died. That's not even a murder. And Evan Holtman, he talks about murdering a woman, very graphic description of murdering a woman on Cape Cod. Again, he says he cut her into pieces and buried her. It's in the wrong place. They're the wrong details. It's not clearly the crime charged in either instance. And it is, of course, extraordinarily prejudicial because the jury could find that he's describing other crimes that he really did commit.
I guess I'm asking you, isn't that appropriately a jury question in this case?
Well, a jury question whether or not he's describing the crime charged.
Or whether this is
it's
an
a jury
admission
question if I think this is essentially different from asking, whether allowing a jury to analyze the meaning of, a wink or an apology. the judge in the first instance has to make a decision that the jury could find that he was describing in these instances the murder charged. And I don't think you could make that finding.
In the trial, in his or her closing argument, did the prosecutor argue that this was appropriate propensity evidence, or was the prosecutor arguing that this was an admission?
An admission.
Okay.
In both cases, it's brought in as, they're brought in as admissions, and they're argued that they were admissions. The defendant also made a statement to police. Within days of his indictment, Attorney Bruce Ferg, CPCS attorney, who had previously represented Anderson, had himself appointed to represent him in this case.
Not really appointed, though, right?
Excuse me?
No, appointed in what sense? The court didn't appoint him.
No, at that point, the court didn't appoint him. He basically got an assignment from CPCS. I don't think it's really all that critical whether or not the appointment was fully executed at that point, or even whether
the defendant even knew. I mean, the defendant hadn't requested counsel. He hadn't
requested counsel, hadn't been arraigned, yes.
Well, how do you deal with the Patterson versus Illinois U.S. Supreme Court decision on this point? Is this distinguished from those facts in some fashion?
We're not really focusing on the question of his appointment. I think the problem is that the state, not really with any issue about whether counsel had been appointed at this point.
No, I know Patterson has nothing to do with whether counsel had been officially appointed or not, but at least, and Patterson, actually, you may say Patterson is distinguishable because counsel hadn't been appointed. I mean, maybe that makes a difference.
But didn't he requested to talk to the police, correct?
He did.
The police went down there. They showed him.
They showed him the letter.
The letter that said Mr. Ferg has been, CPCS has assigned Mr. Ferg, and he says, I'll still talk to you. How in the world can there be any problem with that?
Because he can't make no defendant can really make a knowing and intelligent waiver without the advice of counsel. And this really, I guess, really just hinges on the question of whether you think that defendant can validly waive the right to counsel without advice.
But that's what Patterson
Well, that's actually
said.
raised in the next case, if you want to know. The next case, they're asking us to adopt the New York rule that says you can't, after counsel...
I am asking the court.
This case.
I'm arguing that under Article 12...
I apologize.
Under Article 12, not the federal Constitution, that...
Because the Patterson case sinks you on the federal Constitution.
Exactly. But under Article 12, we need to ensure that defendants' waivers of their right to counsels are knowing and intelligent.
Particularly after indictment. Particularly after formal charges have been brought.
Yes, and the defendant is represented by counsel.
But the New York rule is based upon the language of the New York Constitution.
That's true.
Which is entirely different than ours.
It's different, but both constitutions emphatically protect the right to counsel. And with language that's more...
Well, New York says it's the defendant and counsel.
Yes.
And our Constitution says the defendant or counsel.
It's not that. Adopting the New York rule won't mean that defendants can't proceed without counsel. And, in fact, in neither state could you have a rule that didn't allow the defendant to proceed without counsel. All it requires is that the defendant make that decision with the advice of counsel.
Well,
Didn't they show him the letter?
And they did.
They showed him the letter, so he knew what Ferg's advice was.
He knew what Ferg's advice was, but he wasn't able to confer with Ferg. Yes, but it's not just to know that Ferg had said that he didn't want the state to talk to him isn't the same as talking to his attorney, finding out what his options are, learning, how he could damage himself. And in fact, this was ultimately not the choice he wanted to move forward with.
But in fact, in the New York case, he had already obtained the advice of counsel. And what New York was doing, he'd already spoken to his lawyer. And what New York was doing is saying, you can't waive it unless your lawyer's there. As I understand your argument, you're saying he hadn't had an opportunity to consult.
No, I'm saying that before he could waive his right to counsel, that Massachusetts should adopt the New York rule.
And say that the lawyer has got to be present at the time he waives?
Yes.
In essence, after indictment, the whole landscape changes, right?
Yes.
It's the indictment that is the
trigger.
The trigger.
Right. Police can still go around and talk to suspects before indictment.
Right.
They don't have to.
And I take it your position is that after indictment, certainly someone can decide to represent themselves, but at that point, that should be, A, after having had the ability to consult with counsel on the subject, whether appointed counsel or his own counsel, and surely only after the court has conducted an inquiry as to whether or not waiving counsel after indictment is what he really wishes to do. Because ordinarily, if one waives counsel after indictment, the court has to make very certain
If he's actually proceeding and representing himself at trial, yes. But
so prior to trial, someone is indicted for murder. We're not talking misdemeanor shoplifting here. The defendant could simply waive counsel in a discussion with the police, waive his right to counsel in the proceedings with
after indictment.
Wouldn't he have to?
After indictment, if he has counsel, he cannot. The police need to have counsel present.
Let's assume he comes into court. He has no counsel.
Okay.
The court says, the court actually doesn't say, do you want a lawyer in a murder case? It says, can you afford a lawyer? If you can't, we're appointing a lawyer for you. But he comes right into court and says, I don't want a lawyer, I want to represent myself. The judge is certainly going to make significant inquiry, probably even insist that he consult with counsel about that decision, right?
Right.
Pretty serious decision.
Yes. And that sort of creates a kind of in a different context, a sort of parallel procedure where the defendant is fully advised of.
Right. And what you're saying is that kind of very deliberate decision after indictment can't simply be made in a context of the police and an assistant district attorney sitting down with a defendant and saying, oh, by the way, you have the right to counsel? All of these other rights. In fact, there's a letter here from a lawyer. I know you don't know this lawyer, but he says he's available to represent you. But you can waive that right. That's not the kind of proceeding in which that kind of very important decision should be made after indictment.
I mean, part of the reason the prison had this policy of informing inmates that they'd been indicted was it was a security measure. They were concerned that inmates would become overwrought. It can be, and I think typically would be, an extremely sort of traumatizing experience. And somebody making this decision without the advice of, a objective level head, informed level head, is really not acting voluntarily or knowingly.
Could you review me precisely what he said in this statement? I mean, a part was spontaneous before this happened, that he blurted out he wanted to plead guilty. There's nothing, it seems to me, that's problematic about that. It was initiated by him. But after that, once he actually had the conversation, what did he say?
He had an extended conversation with Lieutenant Nagel, and he said he was innocent. And he talked about where he was. He knew exactly what he was doing on that day, although he got the month wrong initially. Then he says he was out collecting pine cones with his wife. He makes a number of statements he just explains how he knew what day of the week it was, and he makes a number of statements that, while not admitting the offense, are arguably inculpatory. And I can't remember
And how is
the
it
entire...
how was it used at trial? Was it argued in closing, for example?
I think if I recall correctly, it's argued in closing that he admits that he owned a car fitting the description of the car in the park.
But I take it others had testified. In fact, his son and others, had they testified?
There was a lot of evidence about the car. I actually don't recall to what extent it was used in closing. And if there are no further questions.
Thank you, Ms. Robinson. Thank you, Ms. Lee.
Good morning. May it please the Court. Mary Lee, Assistant District Attorney for the Commonwealth for the District of Plymouth. With me is John Bradley, Deputy First Assistant in Plymouth County. I will begin my comments regarding the first issue, which is the defendant's post-indictment statement to police, which he initiated. He was informed of the indictment as a matter of security by Lieutenant Colonel O'Farrell in the prison in Thomaston, Maine. His statement, "I want to plead guilty," was admitted at the motion hearing, but not at trial. O'Farrell did not testify at trial. So O'Farrell contacted Sergeant Nagel in Massachusetts, and the defendant was then interviewed as he had requested and invited the authorities. So the question here becomes, can the defendant, in these circumstances, after indictment, when the right to counsel has attached, waive his right to counsel in the absence of counsel?
Could he if he had counsel?
Of course he could if counsel was present, yes.
No. Could he have waived it? Let's assume he had been appointed counsel, then contacted at arraignment or in some other proceeding after indictment, and had then contacted the police or the district attorney's office and said, I really want to talk. I'm going to waive my right to counsel. I want to talk to you. Is that okay?
When counsel is appointed or retained by the defendant, 4.2 kicks in, and the prosecution's office cannot have any involvement, obviously, in making those arrangements, as they did here.
And you say 4.2 didn't kick in here because although counsel had been assigned
by CPCS,
he had not.
He had never requested counsel.
Requested counsel.
The court had never appointed counsel.
Right, but isn't that a matter of timing? Isn't that just a matter of time? In fact, the court appointed Mr. Berg as his counsel just a few days later.
Yes, 3 days after the interview, the court appointed Mr.
So
Berg.
would it have made a difference after counsel had been appointed by the court?
Under 4.2, yes, and in which case the interview would not have taken place.
Constitutionally, it wouldn't have made a difference?
It does not under Patterson. Patterson versus Illinois.
Patterson,
the
defendant wasn't appointed a lawyer. He had just been informed. And
I would suggest at page 290 of note 3 of Patterson, the Supreme Court notes, it was significant that the defendant did not request, retain, or accept appointment of counsel. At that point, Maine v. Moulton kicks in, which is the case the defendant relies upon the knowing exploitation by
But in Patterson,
authorities.
counsel hadn't been appointed, right?
Right. This case is not distinguishable from Patterson. So under the Sixth Amendment,
it may be distinguishable if we conclude that the assignment of counsel by CPCS under their authority is the equivalent of an appointment after indictment.
If you conclude that, but I would suggest that the facts and the law do not support that.
Why?
Because
What do the facts and law have to do with how counsel is appointed?
if there's counsel in the case, then 4.2 is an issue. If there is no counsel in the case, then it is not.
And you're
the
saying,
court has not appointed
counsel
it.
is not in this case.
Correct.
But he would be in this case if the court had appointed him.
Yes.
But not CPCS under their authority to designate lawyers for people in these circumstances.
They are constricted by the restraints of 211D, which is, in the Commonwealth's brief, and Quegan, which is a parole case, says CPCS doesn't have authority beyond that. And even under CPCS's own policies, which were testified to by Mr. Leahy during the motion hearing, they don't do a pre-arraignment assignment unless the defendant requests it, and the defendant didn't request it here.
Ms. Lee, let me ask you this question. Adult child is arrested. Attorney arrives with a letter from the father retaining the lawyer to represent adult child. of course, adult child doesn't know yet because the communication, hasn't,
Certainly.
in this case, he was shown the letter, right?
He was, and he signed the letter.
During the interview.
Not only was he shown the letter, but the officer told him Attorney Ferg intended to represent him and that Attorney Ferg did not want him to talk to the authorities. Then he showed him the letter, the defendant read it, and the defendant signed it, and it's in their record appendix.
Now we're on the parallel scenario, and you've got the adult father, you don't have a statute saying you haven't been appointed.
Mm-hmm.
Same result?
The defendant, the situation you were describing is like Mavrodakis and Valsak, and the Commonwealth abided by Mavrodakis and Valsak in this case by showing him that letter. I would suggest Patterson controls the Sixth Amendment, so then we look to Article 12. Is there something in Article 12 that requires the presence of counsel? And in fact, it's the opposite in Article 12. Article 12 says the defendant has the right to be fully heard in his defense, not in court, in his defense, by himself
That's not
or
what
by his...
this case is about, though. Surely that's so, but this is about whether the Commonwealth can, without the presence of counsel and after indictment, get a waiver from the defendant.
If the defendant initiates, yes.
Okay, so that's an important factor.
Oh, yes.
If the defendant hadn't initiated, that's a difference?
Well, particularly in this case, because in 1995, the defendant had invoked his rights to counsel under Edwards and the Sixth Amendment, as well as Article 12, I would assume. So
what you're saying
he was
is that
reminded of his...
even if you are represented by counsel, there's no question. The only thing that constrains you is 4.2. The only thing that constrains the Commonwealth.
When there's an initiation by the defendant.
Yes.
Yes.
Well, let me just explore that for a minute. If the defendant approaches a police officer and not a prosecutor, is there anything that prevents a police officer from accepting a statement from a defendant?
And this is after indictment with the appointment
Yeah.
of counsel. No. But he has to have a knowing waiver.
Well, in this case, he
have a
shows him
waiver
the
of
letter.
counsel. Yes.
The defendant signs the letter. There's no prosecutor in the wings on this thing.
Right.
And that statement would be admissible.
If he has a knowing and valid waiver, yes.
What's a knowing and valid waiver? Let's say...
Well, I'd like to, if we could look at this case...
I want to understand what the implications are that you're urging. The defendant has an attorney. He has an attorney. And he initiates and says to an agent of the Commonwealth, not an attorney. So it could be a police officer, it could be a prison guard, it could be whoever it is, and says, I want to talk to you.
Yes. The Collins case that's pre-indictment, but the Collins case out of this court
This is
is retention of counsel.
Post-indictment.
And the cases that you're probably referring to when there's no initiation, if I may.
This is Sixth Amendment has absolutely positively attached.
You're talking about Howard and Hilton govern that area with the court officer and then the DSS worker. Howard is a fairly recent case. And those were government-initiated questioning. So
I'm talking about the defendant.
The defendant initiates, he has counsel, the right to counsel is attached, and he is permitted to give a full and knowing waiver.
And what's the case that says that?
I would suggest it's Michigan v. Harvey, but not sure if that's the exact fact pattern. Because I'd like to address this.
But you would say that 4.2 would restrain you in any event in those
No, it
circumstances?
would restrain the
It restrains the prosecution.
But not an agent of the prosecutor?
No, but an
Unless
agent
the
of
prosecutor-
Commonwealth, an agent of the because I want to say the Commonwealth, because I'm going to assume for this.
4.2 only applies to lawyers.
No, I understand that. But
And
you're
so I
saying
can't
that we-
direct someone.
I was going to surely, if you direct
Exactly.
somebody, yes, go ahead and
And
talk
in
to
this
that
case,
person.
there's direction. There's evidence of direction.
So as I understand
officer-
the Commonwealth's position here, somebody is indicted, they are represented by counsel.
Yes.
Absolutely clear that they are represented by counsel. They are incarcerated in Bridgewater, and they say to a prison guard, I want you to get a policeman down here. I want to talk to a policeman. And the guard says, fine, and he gets the police officer in, and he says, I want to confess to the crime.
Read from Ms. Miranda rights.
The federal cases say that the Sixth Amendment can be waived after the right to counsel has attached.
Patterson. That's Patterson.
That's Patterson. And there's no
But there's no
Patterson's
counsel
just
in
like us.
Patterson.
There's no counsel in Patterson. But that's the case. So Patterson controls this issue on the Sixth Amendment. On Article 12, I would suggest the language of Article 12 controls this situation. And I would suggest that the case here shows a valid waiver. The defendant, He knew how to invoke counsel. He did it in 1995. He was reminded of his invocation. He said, I want to get this over with. He's given his Miranda warnings orally and in writing. He signs those warnings. That is sufficient under the law to waive the Sixth Amendment and Article 12 rights, even after indictment. And then the defendant is informed of Attorney Ferg's intent to represent him in the case, and orally and in writing that Attorney Ferg doesn't want him to talk to police, but he wants to talk to police. He gives an alibi. He says he was with his then living, and then at the time of the statement, deceased ex-wife, essentially out with her while his current wife at the time of the crime was working. So he didn't do the crime. He said he was innocent. He said that he denied all involvement in the crime. He told that he had a blue Chevy Nova, and he told that he had a knife, a gun, and he drank a lot at the time. What came in at trial is the blue Chevy Nova, cumulative of tons of other evidence. I mean, we have pictures of the car. Many witnesses testified about it. And the roof racks for the car, pictures of those, tons of evidence about that, and his alibi. The other stuff, the knife, the guns, the discussions of his prior convictions doesn't come in. His denial of the case.
It could have come in, though, you say.
The prior convictions were excluded under the interlocutory appeal in this case in Commonwealth versus Anderson.
But the guns, the knife, and all that.
We could have, but we didn't put it in through his statement. We put it in through voluminous other evidence. And none of those statements, the defendant's statements, were not argued in the closing arguments by either defense counsel or the prosecutor, and they weren't mentioned in the opening statements. So regardless, the only thing that came in just through those statements is his alibi. That's what he wanted to tell the police.
Surely,
when they,
if you're talking about someone who may or may not have known about his rights, you've got a very sophisticated person here who knew exactly what he was doing, who tried to manipulate the police into buying this phony alibi.
Yeah, in addition to that, no one knew the consequences better than he did. He's sitting in Maine, Thomaston Prison in Maine. He knows what happens when you get convicted in these cases. So I would suggest you don't have the policy that came out behind People v. Hobson that created the New York rule, where you have a person in custody who's afraid and unsophisticated. You don't have that. You don't have the language of the New York Constitution. If you have a 4.2 violation, if this court finds that there was an appointment, I would suggest the evidence says there is no appointment of counsel, no acceptance of counsel, no retention of counsel, and no request for counsel. But if, even on those facts, you find that there was a violation of 4.2 that does not require suppression, certainly not in this case, where the inculpatory evidence was cumulative of there were witness upon witness on the blue Chevy Nova and the roof racks.
Ms. Lee, can I just, I know generally, just to go back on the appointment of counsel,
Sure.
Because I'm not as concerned here as, what we're laying out in other circumstances, because I think you've made a fairly compelling case that whatever we do on each of those other pieces, there's plenty of other evidence. And I have
Except for the alibi, which is self-serving.
No, but I have to say I find it very helpful that the Commonwealth passed so carefully so that we don't end up with, you got the knife in through his statement. It's very helpful. One of the things that concerns me about and I don't want to suggest that I don't take the statute seriously, but sometimes the timing is very important, and it's not always possible to get an appointment. I mean, this is not one of those, emergency response kinds of situations where you want to get hold of a judge to say, I need this appointment. And so I would be concerned that there might sometimes be a day, more than a day, before you can actually confirm the appointment, and presumably I take it that's what the lawyer was doing in this case, which was moving as fast as he could.
He did. They provided the letter of assignment and request for appointment to the court 2 days before the interview.
Let me state it differently. Is there any reason to believe that the court would not appoint counsel in these circumstances? In other words, the statute might be read for the appointment of counsel for certain purposes, namely
indigency, et cetera.
A very valid public policy. But for these purposes, I think we've had some cases where the lawyer is a CPCS lawyer but doesn't have a letter. Here you have a confirmation that this case will be handled by this lawyer. And it just concerns me that to say, no, you've actually got to have the appointment.
Well, my feeling on that is that the statute constrains CPCS's authority to appoint itself and insert itself into a case. And it is the defendant who gets appointed by the court finds him indigent and appoints him a counsel, and as the defendant who then accepts that appointment, and having a lawyer come in and insert himself into the case without court appointment and without the acceptance of that defendant, unfortunately ends up with the situation of a violation of Article 12, because it is no longer the defendant's election to speak to the police. It is the lawyer's election at that point to speak to the police.
No, he has the perfect election to speak to the police so long as it is clear that in this context, after formal indictment, his waiver meets all of the constitutional requirements, which normally requires a judge and a colloquy. This is really important stuff.
I agree. And if I may, in this case, we really see why the defendant wanted to talk to the prosecution so quickly. One of the things he said, which I neglected to mention because it wasn't offered at trial, is that he wanted to stay in Maine for a while because he wanted to arrange his personal effects. And that was the request that was granted by the prosecution. If he had been brought down to Massachusetts and appointed counsel as quickly as possible, then he would not have been able to make that request. He would have been brought to Massachusetts before he wanted to go. It's a personal request. It was his interest, that he was serving his own interests, and that's one of the things Article 12 lets you do. It might seem unimportant to us, but it's his life's work.
Ms. Lee, to go back to the appointment of counsel, from the state's point of view, and again, I'm not looking to sort of narrow 4.2 things, but from the state's point of view, if somebody says, if a lawyer says, I represent, in other words, if this lawyer had simply come in and said, I represent, what I'm trying to do is, think of police officers on the ground. I mean, they don't know the interstices of whether or not somebody's technically, he may be able to waive. Correct. I mean, that's why I went to the father situation as well. It's the same thing. You have to tell, and he may nevertheless speak. But don't we want a rule that says as long as there's a lawyer representing that he has been retained for purposes of how we then proceed for these purposes, the Commonwealth should assume that that person has been retained.
And I would suggest from a lawyer's perspective, you have that rule with 4.2, and from the police perspective, you have the Collins case, which granted his pre-indictment before the right to counsel was attached. But there was a lawyer retained in that case.
No. I'm not getting into whether there's been a violation of 4.2 or anything else, but just for purposes.
What we should want, yes.
So that we have, as it were, a fairly clear rule, so that people are proceeding knowing that he is now represented, pre or post indictment. You can have a knowing and valid waiver, maybe, but...
I feel we're bound by the language of Article 12 that provides an explicit right of election.
No, I'm not getting to the election. I'm getting to whether or not we should consider that he is, in fact, represented by counsel, even though under the CPCS statute he has not been appointed.
I see what you're saying. And in this case, the law says what it says, and the facts are what they are, and the official appointment was not until 3 days after the interview in this case. Okay. And that is why the Commonwealth is suggesting that there was no impropriety under 4.2, certainly not under the Sixth Amendment and under Article 12's right of election. I see that my time has run out, but I believe Mr. Bradley still has 2 minutes. So am I incorrect on that, or have I read the clock wrong?
I thought he was given 5.
Oh, 5. Okay. So, well, I've gone over, I meant,
You
yes.
can hardly say, may it please the court, in 2 minutes, so thank you. You have not used up Mr. Bradley's time, I can
Thank you so
assure
much, and I will rely on issue 2 on my brief. Thank you.
Mr. Bradley?
You may not need all 5 minutes, Mr. Bradley.
That's my hope, Your Honor. I'll try to confine it to 2. May it please the Court, John Bradley for the Commonwealth. I'd like to just address the issue concerning the statements made by the defendant to 2 of the inmates, Carol St. Germain and Evan Holtman. The Commonwealth offered these statements at trial as admissions. There was a motion in limine conducted by the trial judge before we started the trial, and ultimately the judge ruled that the statements made were sufficiently similar to the killing of Ruth Masters to enable the jury to conclude that the defendant was talking about the death of Ruth
And
Masters.
that's a discretionary ruling, and
That's a discretionary
appears to be
ruling.
no error with regard to that here, correct?
That's right, Your Honor. Well, he didn't specifically mention that he killed Ruth Masters, and the words that he used weren't, I guess, entirely clear. They were close enough. And that's the way the judge ruled, and it was really just a jury question, and it was properly left to them to determine whether he was talking about killing her in the state forest back on May 14th of 1977. And unless the court has any additional questions, the Commonwealth would rest on its brief.
Thank you, Mr. Bradley.